2019-1498, Rayco Manufacturing Incorporated versus Murphy Rogers Sloss and Gamble, a professional law corporation et al. For the appellant, we have Mr. Likens.
Chief Justice O'Connor, may it please the court, my name is Andrew Likens. I represent the appellant, Rayco Manufacturing, Inc. I'd like to reserve 3 minutes for rebuttal. The appellees in this case filed a motion to enforce an alleged settlement agreement. The parties stipulated to emails and messages exchanged by counsel regarding the settlement, but the trial court still believed that a issue of fact existed as to whether a contract was formed. It impaneled an advisory jury to determine that issue, and the advisory jury deliberated for approximately 4 hours before determining a contract was even formed. Rayco actually prevailed on the factual issue raised in the motion to enforce. Namely, the jury found that a January 26, 2017 letter was not an offer of settlement. However, the jury accepted an alternative theory advanced towards the end of trial regarding a February 23, 2017 email also being able to be considered an offer. Because the motion asked only for a hearing on whether a contract was formed, that was the only issue decided. The trial court did not find that the contract was breached, and there was no evidence presented that the appellees had performed or been damaged. The trial court refused to award fees because it determined that the American rule applied and then no exception to that rule had been established. In doing so, it specifically held that there was insufficient evidence of bad faith. Without finding that the trial court had abused its discretion, the 8th District nevertheless reversed the decision not to award fees. In doing so, it mischaracterized the lower court's finding as a determination that the contract had been breached, and also contended that labeling attorneys' fees as damages took the case outside of the American rule. The 8th District awarded fees even though, quote, none of the other exceptions applied, thus implicitly conceding that it was really creating a new exception to the American rule, and at the same time conceding that insufficient evidence of bad faith had been established to trigger the existing exception. Adopting the 8th District's decision would open a Pandora's box of policy issues. It would allow courts to decide which public policies should be supported with a fee award rather than the legislature, and encourages litigation because it rewards a party for proving even a technical breach with fees without imposing consequences for failing to establish a breach. It allows recovery of compensatory damages on a motion for reasons not raised in the pleadings. It allows recovery for breach of contract even without proving all the elements of breach of contract. It allows a party to specifically enforce a contract while also recovering damages for breach of the same contract, and it overrides freedom of contract by not honoring the party's decision whether to adopt a loser pays approach. This flows from the 8th District's decision to adopt the Shanker line of cases, which held that attorney's fees may be awarded in a breach of contract case if the fees were incurred directly as a result of the breach. Shanker was decided 20 years ago, and no other state has recognized the proposition of law that it adopted. However, the U.S. Court of Appeals for the First Circuit has expressly rejected Shanker's approach as inconsistent with the American rule. Thus, it is not surprising that Shanker...
I'd like to ask you a question. Did the appellate court, first of all, the trial court did not find bad faith here, did they?
That is correct, Your Honor. They found that there was insufficient evidence of bad faith. Okay,
so how did the appellate court deal with that concept of bad faith?
It essentially held that bad faith was not necessary to be shown because they were going to award fees as damages rather than as sanctions.
So it was just merely the semantics that allowed them to go from, to recharacterize the fees.
That is our position, Your Honor, and I believe that's consistent with this court's precedent. This court has held in Michaels v. Morris in 1956 that litigation costs or attorney's fees constitute litigation costs rather than damages. In State Electoral Beacon Journal, it said Morris settles that issue, and it reaffirmed that as recently as Christie v. GMS Morgan in 2000. Likewise, the court has also held that attorney's fees cannot be awarded as compensatory damages for breach of contract in Gates v. City of Toledo.
Counselor, I'm curious here. When I look at this agreement, it says that the law firms agree to release Rayco from, quote, all claims for attorney's fees and related expenses incurred in connection with the agreement. Why didn't you just argue that attorney's fees were barred by the terms of the release?
Well, Your Honor, That's true. And it's also true that when asked if the agreement provided for a loser pays or fee shifting provision, the appellees in this case specifically told the trial judge that this contract does not provide for fee shifting. So not only does that provide for it, but there was no.
But did you argue though below that that under the agreement they agreed that they weren't entitled to attorney's fees in connection with it?
That was not specifically argued below, Your Honor.
Why not?
I believe the parties were focused on the American rule. That's what the trial court judge had specifically framed the issue as. And since the American rule clearly barred the fees, that was the argument made. And as Chief Justice O'Connor noted, this is largely a semantic issue in the United States Supreme Court. 224 years ago, it rejected the same effort to recharacterize attorney's fees as damages in Archambault v. Wiseman. The court has also held that new exceptions to the American rule are a legislative issue in Soren v. Board of Education, which recognized that whether to shift fees is a policy decision and therefore a matter of legislative concern rather than judicial concern. To quote the court, any departure from such a deeply rooted policy as exclusion of attorney's fees as cost is a matter of legislative concern, and the subject of cost is one entirely of statutory allowance and control. The 8th District admitted that there was no statute that provides for fee shifting if a settlement contract is breached, and instead relied upon this court's decision in Purcell v. Sterling Industries, which recognized Ohio public policy encourages settlements. However, Soren stands for the principle that it is up to the legislature which public policies to support with a fee award. That is consistent with the United States Supreme Court precedent on this issue, including an Alyeska pipeline, which stated that public policy is not a grant of roving authority to the courts to award fees. In fact, this court has held that public policy supports the enforcement of contracts in general in Bell v. McConnell. However, as noted earlier, the court has consistently held that courts cannot award attorney's fees for breach of contract. What the appellants are doing in this case is trying to apply a fee shifting provision into every settlement contract because the contract that they drafted does not provide for fee shifting. However, this court has stated that it will not read a fee provision into every settlement contract or into contracts the parties do not agree to, and Stata Auto v. Mutual v. Grow, which is consistent with this court's general line of cases, saying that a court will not rewrite a contract for the parties. Further, the contention that a party should be made whole for breach of contract is inconsistent with this court's precedent. This court has long refused to allow a fee award for breach of contract. And as former Justice Cook acknowledged in Brandenburg, the American rule often means a party will not be made whole. As the U.S. Supreme Court has stated, it has expressly rejected the argument as to the American rule in Norfolk v. Appellant, stating that a court can't award fees to a recovery to make a party truly whole under the American rule. In fact, the appellees haven't cited a single case where fees were awarded just to make a party whole for breach of contract. They instead rely upon cases where one party contractually agreed to pay the fees of another. However, courts awarding fees as compensatory damages for breach of contract have admitted that is inconsistent with general contract law. The Schenker line of cases has led lower courts astray by treating settlement contracts as somehow different. In Sheets v. Aho, the 5th District held that fees can be awarded if they are incurred directly as a result of breach of contract and bad faith is shown. The requirement that a movement show bad faith is consistent with the American rule. However, Schenker cited Sheets as allowing fees to be awarded as damages if they flow directly from the breach. Ignoring the bad faith requirement took this line of cases outside the American rule. Sheets and Schenker were not limited to breach of settlement agreement cases. Sheets itself involved a real estate purchase agreement. However, 15 years after Schenker was decided, the 10th District in Tejada held that Schenker was limited to breach of settlement agreement cases in an apparent attempt to bring this line of cases back within the American rule. However, it failed to identify any basis for singling out one type of contract for special treatment, and the new exception seems to be created more by accident than an intentional decision to ignore this court's precedent or the reasoning behind it. The 8th District's approach is also procedurally flawed, as it allowed the appellees to seek breach of contract damages by filing a motion. A motion is fundamentally different than a breach of contract action. A motion fails to invoke the court's jurisdiction to award damages And further, a breach of contract requires proving 4 elements: that a contract was formed, that the movement performed under the contract, that the opposing party breached, and that the movement suffered damages as a result. A motion to enforce requires the movement to prove only the first element. It's the equivalent of a declaratory judgment action or specific performance action. The revised code specifically provides that declaratory judgment actions that fees cannot be awarded in those unless a statute provides otherwise or frivolous conduct is demonstrated. In the end, the 8th District allowed a breach of contract damages without the appellees showing all the elements of breach. This raises a second procedural problem with the 8th District's decision. Namely, RACO demanded a jury trial in the case for any issues so triable. The breach of contract and the amount of any resulting damages are both jury issues. In Christie v. GMS Mortgage, this court held that if attorney's fees are damages, they must be determined by the jury. However, the 8th District treated the case as resolving the issue of liability and remanded for a damages hearing only. RACO was entitled to a jury trial on both the issue of breach of contract and damages. However, if the hearing was the trial on breach of contract, then damages was a necessary element of proof in that trial. Appellees, however, did not present any proof of their damages or that they had complied with the contract. The appellees didn't inform the trial court that they were seeking compensatory damages until after that trial. That's too late to prove breach. It's too late to preserve RACO's right to a jury trial. And in fact, RACO would never get a jury trial on the issue of breach because appellees that under the 8th District's decision, because they remanded only for a determination as to damages. The only reason to create a new exception in this case would be if existing exceptions were inadequate. As this court held in Soren, that's really a legislative decision. However, even if it were up to the courts, many of the cases where courts award fees as damages actually include evidence of bad faith. The fees could be awarded in those cases without creating a new exception or going against this court's existing precedent. The remaining cases are those like Tejada, where a party was rewarded for proving a technical breach, despite the fact that the claim for damages other than attorney's fees were deemed meritless, or cases like this, where there was a legitimate issue as to whether a settlement contract was even formed. The 8th District used a fee award to punish RACO for seeking a ruling as to whether or not there was a contract was formed. However, fees can't be awarded just because a party insists on the disputed issue be determined. Ultimately, the 8th District's decision undermines public policy that it purports to promote because if parties are less likely to discuss settlement if settlement disputes will always lead to a fee award. I'd like to reserve any remaining time for rebuttal.
Thank you. Thank you. Counsel?
Thank you, Your Honor. My name is Ernie Fargo with the law firm Baker Hostetler. We represent the lawyers and law firm of Murphy Rogers. With me is Mr. Tim Brick of the law firm Gallagher Sharp. Mr. Brick represents the lawyers and law firm of Cavich Familo. By agreement with Mr. Brick, I will present the argument on behalf of all appellees. Mr. Brick is available, however, to the extent there are any questions unique to his client. May it please the court. This is a question of whether parties to a settlement contract are entitled to their expectancy interests or benefit of the bargain they expressly negotiated for. Appellants seek to deny the law firms the benefit of their bargain. One of the core benefits of this settlement contract was to eliminate legal fees. The whereas clause in the contract made that clear. Of course, another core benefit was to manage the risk of the litigation, but just as central was the benefit of stopping legal fees, or to buy peace, as the appellate court described it. And when a party breaches that contract and forces additional legal fees to be spent, the non-breaching party has lost the expectancy of that contract or the benefit of that bargain.
Counsel, why is not the bad faith exception that exists to the American rule sufficient to protect these types of issues? I would imagine that most motions to enforce settlement would not involve the protracted litigation that this particular case did on an advisory jury and such. It would probably amount to just a filing of a motion and perhaps a short hearing to determine whether there was a contract or not and bad faith existed. Why is that not sufficient?
because the very benefit of the bargain was the avoidance of legal fees. To impose a burden on the contracting parties to prove bad faith, simply to be entitled to its expectancy interest or benefit of the bargain, would be inconsistent with how we treat every other contract. In a settlement contract, the essence of the agreement is so the party does not have to pay legal fees anymore. It is a matter of contract law, not a matter of good faith or bad faith. The party breached the agreement here and deprived the law firms of the benefit of that bargain.
Speaking of the bargain, what about the language I asked opposing counsel about, where it says that the law firms agree to release RACO from all claims for attorney's fees and related expenses incurred in connection with this agreement? That seems pretty broad, doesn't it?
Yes, thank you for that question. Both parties mutually released each other from all liabilities, claims, including attorney fees incurred in the underlying litigation, in the underlying legal malpractice.
It's just in connection with this agreement. That's the language of the settlement agreement.
Certainly the intent, and that's why that is why appellants did not argue this below. It was not a focus on the American rule. It was not argued because the parties intended by their wording to release all claims, including attorney fees relating to the legal malpractice claim below. Certainly nobody contemplated that if either side breached this settlement agreement, that this language would be used to release a claim for attorney fees. Appellants, Your Honor, took the position that there was no settlement contract. There was no settlement contract, and therefore there was no release language in there. Only when we proved there was a settlement contract are we then allowed our expectancy interest or the benefit of the bargain, and that is the legal fees incurred to enforce that contract. That release language.
I guess, leaving aside that language for a second, back to the main thrust of your argument, I'm having a hard time understanding how damages here are different than in any other contract. Where, I mean, to make someone whole, if you really want to make someone whole, you'd have to compensate them for the legal fees that they incurred to get the benefit of the bargain. Why is this any different?
This is very distinguishable from other contracts. For example, in a contract for the sale of goods, in a contract for goods, the core benefit of that bargain is the delivery of the goods at the agreed to price. Later legal fees spent to enforce the contract in the event of a breach are incidental to the core benefit of the delivery of those goods at the agreed price. Any expenditure of legal fees on a breach of contract claim later are incidental to that core benefit. And that is why so many appellate courts who have looked at this have made the distinction where the spend of legal fees is incidental to the contract.
So what's the line here? I mean, all the time people enter into agreements because they would like to avoid litigation. Is it any time there's an agreement where litigation is a possibility? Does it have to be after litigation has been commenced?
It's not simply where it's a possibility. Again, when parties contract for the purchase of goods or the purchase of architectural
all kinds of other contracts where there may not be a lawsuit filed, but there may be I may sell my house. There may be a defect that's not disclosed. I may settle with the buyer because I don't want to get sued. Am I entitled to attorney fees appropriate in that case?
In that case, in that
there was a breach of that agreement.
In that case, the parties are negotiating to eliminate the risk of liability for the sale of that house. They are negotiating to eliminate the risk of litigation. And part of the thinking for any party.
So do you get attorney's fees for breach of that or not?
Well,
Yes or no?
yes, Your Honor, because part of the benefit of that bargain is I don't want to go into court. I don't want to have to
But
defend.
isn't that part of the benefit of all kinds of bargains out there? I mean,
It could be the incidental benefit of the contract for the sale of goods.
I mean, if I'm in a motor vehicle accident and I settle that claim, presumably one of the reasons I settle is because I don't want to be sued.
That's exactly right. And in that case, as the insured, for instance, in that case, we have many settlements in Ohio involving accident cases, of course. And the insured will use insurance proceeds to pay the other side, the non-negligent party. And that non-negligent party says in that contract, listen, if you pay me consideration, if you pay me your insurance proceeds, I will stop my lawsuit or I will not bring my lawsuit and you will not have to pay legal fees.
So is the rule anytime an agreement includes a release of a potential claim that you're entitled to attorney's fees? The American rule doesn't apply?
Anytime the benefit of the bargain is the avoidance of legal fees.
So we're talking about a really, really broad extension. This isn't just about litigation going on in court. This is about anytime there could be litigation.
If parties pre-suit settle a tort case, they want to stay out of court. That's expressly the benefit of their bargain, and they should be entitled to it.
So that would mean pretty much any time when there's something that could be a tort.
Anytime the parties settle a dispute where they manage the risk of liability and want to pay or accept compensation to stay out of court, if they are deprived of the legal fees that they incur.
So what if two businesses have a dispute? They both think they're right. One ultimately says, you know what, it's cheaper just to settle this. So then you're entitled to attorney's fees in that instance if there's a breach.
Absolutely. Yes, because that is the benefit of that bargain that the hypothetical presents, Justice. That party is expressly saying, I may not be liable here, but I don't want to.
Counsel, are you asking to overrule that outlaw in Ohio, the American rule?
Our position is consistent with the American rule. It does not violate it. It does not require an exception to it. The American rule would apply in the sale of a goods where.
Well, let me give you an example. Okay,
Yes.
in an oral contract in Ohio, you have a right to breach a contract as long as you're willing to pay the damages.
Yes.
Okay,
Yes.
but you sue under the oral contract, there's no basis to get attorney's fees.
That is correct to the extent the oral contract has a benefit of the bargain where the payment of legal fees to enforce is simply incidental, as in the sale of a goods. But if that oral contract, Justice, if in that oral contract, I say, if you pay me compensation, I will take measures so you don't have to spend legal fees in court, and I breach that oral agreement, the other side ought to be entitled to that benefit of the bargain.
That's the word ought. I hear you. I'm just saying, what is the current law in Ohio? Is not the American rule precluding the recovery of attorney's fees in those cases today?
In the sale of goods, it prevents it. But where the parties have an express benefit of the bargain, it does not prevent it, because in this court's decisions, when an insurance company breaches a duty to defend an insured, this court has always held that the insured can sue the insurance company for breach of that duty to defend and recover the legal fees spent defending itself. And that includes the legal fees spent in bringing the lawsuit against the insurance company. And the reason is because that is the specific benefit of the bargain that was negotiated for. And if we deprive that party of the benefit of its bargain, its expectancy interests, they are deprived of contractual damages. There is no contractual reason, no basis in contract that says a party who has an expectancy damage or a benefit of the bargain based on legal fees should be deprived them simply because they happen to be legal fees. It is the appellants who are misapplying the American rule to deprive a party of its benefit of its bargain, its express benefit of its bargain, its expectancy interest. And this court allows the recovery of legal fees in a suit against an insurance company for breach of the duty to defend because it's the expectancy interest that was negotiated. And it was
counsel, if a party has a colorable defense that a contract was even formed in a settlement agreement, shouldn't they be able to defend that without the fear that they're going to incur legal fees absent bad faith?
Well, individuals or entities always may have a belief that a contract was not formed, and they can lose that piece of litigation and they still are bound by that contract. In this case, the contract, they told us, Justice, if you enter into this contract, if you promise to pay this amount, you will not have to incur future legal fees. The appellee should be entitled to that expectancy interest as a matter of pure contract damages.
Mr. Vargo, if I could ask a question. This can all be avoided in the settlement agreements, can it not? If the parties agree, the winner will, if this settlement is breached or argued, loser pays the fees. Or they can agree otherwise. Why should we leave it open to question like this when within the American rule you already have a way that the parties with good lawyers can protect against that?
Thank you for that question, Judge. The separate fee shifting clause is unnecessary in this case because the parties sat down and expressly contracted so they would not have to pay legal fees. It is an express expectancy interest. In no other contract do we require parties to set forth their expectancy interest before they're entitled to recover it. If a seller fails to deliver goods, the buyer can sue the seller for the higher price the buyer is forced to pay elsewhere, less the agreed to price. That buyer does not have to set that expectancy interest in its contract in order to sue for it. It's able to sue for it under basic contract law. Here, the parties expressly contracted for this expectancy to require another fee shifting clause is unnecessary. In essence, this was a 10-page agreement to shift the fees. Both parties knew they would be liable for the expectancy interest suffered by the other party. And both parties knew that expectancy interest was to stay out of court and to avoid legal fees. Now, one argument, and I'll glad to take any other questions, and I know I'm running out of time, but the other side argues that this will lead to claims for immaterial breaches. That's not true. The remand order says that only reasonable attorney fees will be awarded. So if somebody brings a motion or litigation on an immaterial breach, those will not be reasonable.
Thank you. Thank you, counsel.
Oh, thank you, Your Honor. For all those reasons, we respectfully request that the appellate court be affirmed. Thank you very much.
Mr. Likens, you have about 2.5 minutes left.
Thank you, Your Honor. I'd like to begin with the statement that Mr. Vargo made that as to what we told them. I'd like to focus on what they told the trial court. The trial court specifically asked them, did you agree that if a motion to enforce had to be brought, that the loser would pay the other side's attorney's fees? They responded to that question up to the trial court with, we did not agree. That's on page 409 of the joint supplement. Having told the trial court that this was not part of the agreement, the argument that is being made that this was really the benefit of the bargain and something that the parties agreed to is clearly was not an intended part of the contract. If the counsel agreed that expressly, when it expressly asked that question, that was not part of the agreement. As far as the benefit of the bargain, this was a $25 million claim as identified by the appellees themselves in the trial on the underlying litigation. They were able to settle that for 3% or $3 million, which is approximately 12% of what potential claim against them was. That is the benefit of the bargain. As the First Circuit held when considering the Shanker line of cases that they're relying upon, you have to look to the contract to determine what the benefit of the bargain is. The courts of this state have repeatedly held that as well. Even in insurance contracts, as Mr. Vargo is referring to, you look to see what it is the insurance company agreed to do. If there's no agreement to defend in the insurance contract, the courts don't imply an agreement to defend. They've said, we look at it, we determine what it is, and then we enforce it. Getting your fees for enforcing a contract is not part of the benefit of the bargain unless you've specifically agreed to that. Finally, I'd like to address one other issue. In the proceedings below, the appellees filed a motion in limine that stated this is not a trial on the merits and asked the trial court to bar any testimony on any issue other than whether or not a contract had been formed and what the terms of that contract were. So the argument that this was really a determination that the contract was breached is something that they expressly stated below in another motion was not what that litigation was for. That just emphasizes that there's a difference between a motion to enforce and a breach of contract action. Thank you.
Thank you. Thank you, gentlemen. We will take the matter under advisement. You'll be notified of our decision. Thank you, Judge Wise, for sitting. Thank you for sitting in the place of Justice Stewart. We wish you a safe trip back to the 5th District.
Thank you. It's always an honor, Chief. Thank you, everyone.
Our next case this morning is 2019-1674, the State of Ohio versus Ryan Turner. For the appellant, first we have arguing Mr. Ferris.
Good morning, Your Honor.
Counsel, you may proceed.
Thank you. May it please the court, Chief Justice O'Connor, Justices, Mr. Horton. My name is Zach Ferris. I represent Appellant Ryan Turner. I'm reserving 3 minutes for rebuttal and 2 minutes for Mr. Grube of the OACDL, who filed an amicus brief and who will be addressing the constitutional arguments from his brief if necessary. The language of 451133 and the definitions found in 451101, dictionary definitions, and case law throughout the state of Ohio all support Turner's proposition of law that a motorist who touches but does not cross the lane line does not violate section 451133 and does not give an officer reasonable articulable suspicion for a stop. If, however, the court finds that 451133 is ambiguous, the rule of lenity codified in 290104A requires that the statute be construed strictly against the state and liberally in favor of Turner, which mandates a finding that touching a line is not a violation of 451133. A motorist remains in their lane when they touch the lane line, as the definitions in 451101 for roadway and laned highway make clear that the lane lines are part of the lane and can be driven on. The legislature specifically excluded the berm and the shoulder from the roadway used for vehicular travel, but did not exclude lane lines. Since the line can be traveled on, it is the outside edge of the line that marks the outside edge of the lane. The 12th majority in the state attempt to establish the inside edge of the line as the outside edge of the lane by applying outside definitions to the phrase entirely within, which is found in 451133. But this position is problematic for 2 reasons. First, defining within as they do as on the inside or on the inner side is actually consistent with Turner's position. A motorist traveling on the lane line is still driving on the inside or on the inner side of the outside edge of the lane line and thus is in the lane. Second, this is a cherry pick definition anyways. Within is also defined as, for one example, not beyond, which certainly suggests that you can travel on the line but cannot cross beyond the line. So the statutory definition supports Turner's position. The dictionary definitions support Turner's position. Other statutes like 451125 and 451136 show the legislature's intent to allow touching. Every appellate court outside of the 12th district supports Turner's position. Even the 12th decision was a split decision. Finally, the amicus and the state argue reasonable mistake of law on the basis that the statute is ambiguous. Thus, they are admitting that 451133 does not clearly support their position. Thus, I believe that it cannot be said that the language of 451133 clearly and unambiguously supports the state's position. So that leaves us with two options. First, either the statute clearly supports Turner's position, which it does, and which is what appellate courts outside the 12th have unanimously held, or the statute must be deemed ambiguous, and again, based on 290104, it must be construed strictly against the state and liberally in favor of the accused, Mr. Turner. And the only way to do that would be to find that motorists are allowed to touch the lane lines. Now, finally, concerns about safety from the 12th and from the state just do not withstand scrutiny. First, appellate courts have expressly allowed touching lane lines for up to 23 years in various districts throughout the state of Ohio, and there is no evidence that accidents have increased. A review of statewide crash data does not support these safety concerns. Second, these theoretical safety concerns that are proposed by the 12th and by the state all involve motorists deciding to start ramming their vehicles into other vehicles.
Ferris, can I
Yes,
ask
sir.
you a question, please?
Yes, sir.
So as I understand it, under your reading, the strip, the lane lines are really in both lanes, right?
I believe that the lane line can be touched. And
but answer my question. I'm just trying to figure out what lane they're in. So in your view, the painted strip would be in a center line, for example, would be in both of the lanes.
right. So motorists in each lane could touch that lane line. That's correct.
Because the entire strip until the outer edge would be within their lane for both people. So you have
that's correct. Correct.
You have this kind of no man's land that's in both lanes, right?
Correct. And
so, but if that's the case, then how does the language that says you have to drive entirely within one lane make sense? Because under your reading, if you can go in the paint, you're in both lanes.
right. So
you're not entirely within one lane, you're in two lanes. You'd be in two lanes then, right?
Right. What I would say is this. First, obviously that doesn't apply to the fog lines, in my opinion, which is what this case is based on.
But it's the same definition for both. I mean, it's the same prohibition. So we have to think it means the same thing for both the center lanes and the fog lines.
So here is what I would say. Think about airline seats. So you have a seat, armrest, seat. And if you put your arm on the armrest, you're not now occupying two seats. You know, an employee of the airline is not going to rush back and charge you an extra $400 for another ticket because you're now using two seats. But if your hand drifts across the armrest all the way across into the other person's seat, now you have some explaining to do. Now you have an issue. So I think that when you read 451133, you have to do it with an understanding of the definitions in 451101, which, as I laid out in my brief, make clear that the lane lines are part of the lane, part of the roadway used for vehicular travel.
Counsel,
Yes, ma'am.
how safe is it if you're going to say the center line is it's permissible for cars to be driving both north and south or east and west in opposite directions and occupy the center line?
Right. So I don't believe that it creates any safety concerns. First of all, like I mentioned, this has been allowed in districts for at least up to 23 years in certain districts, obviously less than others based on when the appellate decisions were made. And we haven't seen any proof of any increase in crashes, and accident reports does not show that there's been an increase. Second, the center lines are already allowed to be driven on under statute section 451125. And again, we haven't seen any issues with that. The legislature could obviously address that if they thought that there was. Third, just because two motorists have the ability to occupy potentially the same space doesn't mean that they can at the same time. If I am driving on the line and somebody,
Well, who
another
has the right
driver.
of way? Counsel, who has the right of way in your example? If you're approaching one car approaching another, they happen to be just inside the center line, not over it.
Right.
Who has the right of way?
So a person who's touching the line, if there is one.
No, there's two cars. They're both positioned on the same line.
Right. So the motorist wouldn't be able to just ram into one another. Frankly, they still would have the duty to avoid any types of accidents, just like they do now. And if one did ram their vehicle into one another and the police decided who was at fault there's a number of criminal and traffic statutes that would prevent that situation from occurring or hold a party responsible.
Well, how could you tell which one was liable if they both had a right to be there?
Well, they have a right to be there if nobody else is there. It's sort of the same as if you're driving one car in front of the other, and then say motorist A is in front, motorist B is behind. Motorist B, technically under the statute, has a right to use the lane that is in front of him, but he doesn't have the right to ram into the back of motorist A.
Well, there's assured clear distance rules there, but
right.
There's no assured clear distance under your suggestion that the center line belongs to both lanes, therefore belongs to both vehicles. And I just don't understand how you could find fault if there's a collision.
Well, I would say that the same way you would in any other type of accident, you would have to decide who was there, who was allowed to be there, and who moved his vehicle.
Well, how do you do that? That's what I'm asking you. How do you do that under your, your scenario?
The same way you would determine fault in any other accident, I suppose. It would be witnesses, the people's reports, what the police officers found through their investigation, I suppose. But that's already allowed in 451125 again. And if we're going to read that consistent with 451133, then we would have to suggest that 451133 also allows driving on the line. I don't see that as an issue that hasn't already been dealt with for the past 33 years. The other concern with a center line is typically center lines are double yellows. I suppose the court would be within their right to say one motorist can touch one and one motorist can touch the other. I don't think that's the question presented here. So that's not something that's been delved into. But obviously the court or the legislature could decide that as well. Your Honors, my plan now would be to hand it over to Mr. Grube if you have any constitutional related issues. But before I would do that, I would be happy to answer any other questions that you have about the facts of the case, the record of the case, or anything else contained in our briefs.
Okay, thank you. Mr. Grube, how long are you taking? 2 minutes, did I hear?
Yes, Your Honor. Good morning, Chief Justice O'Connor, Associate Justices. May it please the court. Louis Grube here on behalf of the Ohio Association of Criminal Defense Lawyers. We've raised a number of reasons why this court could simply decline to answer the constitutional issue in the first instance. In our brief, we've also provided an analysis that we think the court could use in order to determine that the Ohio Constitution provides more protection in this area and that a reasonable mistake of law does not render a stop reasonable if there was no violation of law. But I think my time is best spent this morning getting out in front of the case Bowling Green v. Godwin, which was provided by the Ohio Attorney General amicus. They make the claim that this is a case that was already decided by this court, that already opened up the can of worms for reasonable mistake of law. And I need to get it across that that was not a mistake of law case. That was simply a mistake of fact case. There was no question in that case that it was illegal if you failed to observe a traffic control device. That was a crime under the Bowling Green Code. The issue in the case was whether there were 6 specific signs in one municipal lot. The question was whether those specific signs were traffic control devices. There was a statute that required the city council to actually validate these signs. And more to the point, this court treated it as a mistake of fact case, not a mistake of law case. So there was none of the analysis that you would have expected. If you look at the Hyen case out of the United States Supreme Court, None of that sort of analysis was provided by the court. The court determined that explained probable cause is determined by examining the historical facts. That's at paragraph 14. And then determined at paragraph 18, in view of all the facts available to the officer at the time of the stop, there was probable cause. So I would just simply ask the court not to treat that as a mistake of law case. And with that, I'd conclude. I'm happy to answer any questions.
And Your Honor, if there are no questions, I'd like to save the remaining 2 minutes and 55 seconds for rebuttal.
All right. Counsel? Is it Mr. Horton going first?
Yes, Your Honor.
Okay.
Thank you, Madam Chief Justice. Justices, may it please the court. My name is Nick Horton, and I represent the state of Ohio, and I will be sharing time with the Attorney General's office. Your Honors, this case is about determining the plain language or giving meaning to the plain language used by the General Assembly in 451133, in particular the phrase entirely within a single lane. The 12th District determined that the phrase meant a vehicle must be driven completely on the inner side of the marked lane lines so as not to touch the marked lane lines, and this court should affirm as such a decision is most closely aligned with the plain language and the intent of the statute. So there are two ways of interpreting the individual lines themselves, and that is either as part of the lane or as sort of a neutral zone or buffer zone. Now, the plain language of the statute and the purpose for the statute indicate that the lines are the buffer zones or neutral zones rather than part of the lanes themselves. So the purpose behind the lines is to prevent cars from inadvertently traveling within the path of another vehicle, or inadvertently traveling on the side of the road, and potentially into another vehicle, pedestrian, or object. In other words, it prevents cars from inadvertently trying to share the same space. So by construing the line as part of the lane itself, it would be inconsistent to say that it's inconsistent with the purpose to prevent this inadvertent sharing of the same space by saying, but cars can share the same space on the lines themselves.
Counsel, when a lane is being measured, the width of a lane, is the line included or not included?
So there is no indication in the OMUTCD or the Ohio Roadway Design Manual. The only case that addressed it that I could find was the Hatfield case, which indicated that the lines were not part of the lanes because, as the court noted, the addition of the end lines or the edge lines and the center double yellow lines would reduce the overall width of the lane. And the language itself indicates that the lines cannot be part of the lanes, because if both cars can touch the center dash line, then by traveling on the center dash line, you are traveling on both the right lane and the left lane, and you cannot possibly be traveling entirely within a single lane.
Counsel, in this case, it's the fog line, okay? Could you address that?
Sure. So the lines can't really be treated any differently for a couple reasons. First is safety. Safety is no less an issue on the edge line than on the center dash line, because with the center dash line, you're dealing with moving vehicles, and it's easier for a moving vehicle to get out of the way of a car that's encroaching on its territory, rather than perhaps on the side of the road where you may have a broken down vehicle or a stopped vehicle, or this is usually where officers pull over motorists for a traffic violation. And if we don't have enough space on the side, then you're close to pedestrians and street signs and telephone poles, all of which would have a much tougher time of getting out of the way of a moving vehicle encroaching on their area. And so I think the safety concerns are even more prevalent on the edge line. So we can't really treat it differently than the center line. I think this is supported by the OMU TCD as well, because the center dash lines are allowed to be crossed, whereas the white edge line, it's supposed to discourage all crossing. And it wouldn't make sense to say that a motorist could not touch the center dash line, the very line it's allowed to cross, but is allowed to touch and ride on the edge line, which it is discouraged from crossing. Additionally, there is no differentiation in 451133 between the center dash line and the white edge line. And therefore, we would be reading in a differentiation that is not necessarily present in the statute.
Except, Mr. Horton, I just want to ask this.
Sure.
The dash line represents a permissive condition where cars may pass safely. And a violation of that, causing an accident, may be something else because it's a permissive condition. So that's not really represented here. But when you get to the OMTCD, and you actually read section 3A06, it says that the solid line discourages or prohibits crossing. It doesn't say the entire entity inside that line. So can you explain this? Why the manual would say it prohibits or discourages crossing, not on an inside edge?
Sure. So the manual actually can't be used to define what is or is not a marked lanes violation, because according to the manual, crossing the center dash lines or even crossing that white edge line would not be a violation. The only violation we would have is if there was a crossing of the solid double yellow line or solid double white line. In fact, when the solid white line is used as an edge line, then it only discourages but does not prohibit crossing. So under
that impart knowledge as to what actually the lane is? Isn't that the whole purpose of this manual and all of the provisions and the markings that go into a roadway? Isn't that really defining the space where cars have to stop or operate within? I mean, this manual was created pursuant to the Federal Highway Administration system and is really across the United States uniform so that these lines all mean the same thing, whether you're in Ohio or Florida or California or Texas. So as it's instructive on what a lane is for all drivers, you still don't believe it has any validity in defining that?
Not as far as defining what constitutes part of the lane and what does not. So it never specifically says what lane markings are part of the lane and what are not. And it can't inform 451133 because under the OMUTCD, crossing those lines would not be a violation. It would be, I think, somewhat similar to the situation in Bibler that this court handled. And so the most appropriate use of this line is to treat it like a buffer zone or a neutral zone, which would create the space between the vehicles or the vehicle and whatever is on the side of the road. And it's supported by the OMUTCD that the inside edge of the line is the line, the edge of the individual lane and the ORC. So where
do I find that then in the OMTCD that it's the inside edge?
So what it indicates is that the white line may be substituted for curbs or parking, and clearly it is the inside edge of the curb or inside edge of the cars that delineate the outside edge of the lane. Therefore, it stands to reason that if those can substitute for the white line, it would also be the inside edge of the white line that constitutes the outside edge of the line. Now, it could be said that riding on the line is within a single lane because you have not yet breached into the adjacent area. The problem with that is that we wouldn't be giving effect to the word entirely. So driving on the line cannot be both driving within the lane and entirely within the lane, because then we're not giving effect to the word entirely, and we're effectively reading it out of the statute, which we cannot do.
Also, immediately before the word entirely, we have the words as nearly as is practicable. So doesn't that in some way modify the word entirely?
No, Your Honor, only as a defense, as this court noted in State versus Mays. And I think is the issue with the third district cases that the defendant brings up, is that those cases focused on practicability and safety, which this court said are not really considerations when we're talking about reasonable suspicion. I see my time is getting short, and I want to make sure the Attorney General's office has some time to address any issues. So we would ask this court to affirm, and if there are no further questions.
Thank you. Mr. Kearney.
Good morning, Madam Chief Justice. May it please the court. We're here today for two reasons. First, to echo the state that driving on the line is a violation of the statute. And second, to urge that even if it's not, this stop was still reasonable because the officer made a reasonable mistake about the law. I'd like to quickly address, if I may, the lenity point my friend on the other side raised, the Godwin point, and also the manual point that Justice Kennedy was asking about. As to lenity, it doesn't apply here because not only is that the last resort if you have ambiguity, and we think here the text resolves it about entirely, but also lenity is about giving the defendant a break on a conviction. Lenity does not apply when we're talking here about whether the violation serves as reasonable suspicion. And in fact, that's what segues into the Godwin point, where this court has already said that a reasonable mistake does justify a stop. As to Godwin, what this court said was that the officer on the ground or on the road trying to enforce law is not like someone taking a bar exam. So I think that pretty clearly says they were talking about mistakes of law. They even talk about the officer's understanding of the law. So calling it a factual case because of the stop signs not being valid, I don't think works. That, and I don't think there's a difference in reasonableness between a factual mistake and a legal mistake, as the Hine case talks about. But again, this court already said so in Godwin. There's no case being made to overrule it. Briefly about the manual and about the as nearly as practicable language, if I can squeeze that in too. One thing the manual does say in section 3A.05.02 is that it's to delineate, quote, the separation of traffic. The key word there, I think, is separation. And of course, as we talked about with the entirely language, if you have a shared space, you're not separating. If you have a buffer zone where you're keeping over here and over here, then you are separating traffic. If you're inviting them to both be on the same space, that's not separating traffic, that's inviting disaster. Further, to address something my friend on the other side said, that notion about shared space doesn't turn on whether someone is actually going to insist on their rights and scrape right up against somebody. No, it shows conceptually that it can't be shared. After all, if someone comes 3 feet over the line, I'm also going to get the heck out of the way too if I'm coming the other direction. That doesn't mean they should be there. It just means we all drive defensively. But you shouldn't set up a... Yes?
When you make a statement about 3A05 that really talks about the delineation of colors and why we use certain colors on a roadway to demark certain areas as passable or prohibited. But it's really the functionality, isn't it, of the longitudinal line when you get to 3A06, where again it says the general function, and as it relates to the solid white line, the fog line, it discourages or prohibits the crossing. Doesn't that really lead me to the conclusion that the lane includes the line and it isn't until you cross it?
No, Your Honor, for a couple of reasons. First, in discouraging crossing, and this actually ties in with and matches the language about as soon or as nearly as practicable, is that there's a difference between saying, look, we want to give drivers some wiggle room to cross for deliberate safety reasons. And the court talked about this in Mays, where they said, look, if you need to avoid something, you know, whether you need to avoid a live deer, a dead deer, a John Deere, whatever's in the road, sure, you can cross. Or if you need to just make a turn, you can do so, but that's when you do so deliberately. What the court in Mays said is that that language doesn't allow you to do so for mere inattentiveness or carelessness, or in this case, drunkenness. And so that delineation is saying, hey, here's where you're be careful. If you need to cross, sure, look both ways, make sure you can. But the allowance we give is for deliberate. And if you're moving deliberately, well, then you're not only allowed to touch, you're allowed to outright cross when it's warranted by the facts. But we don't allow free drifting to just keep on touching, whether once or 100 times, just like we don't allow crossing. Because again, the line has to be conceptually between the spaces or between the allowable spaces, not a shared space where everyone can go. That's simply the matter of the text and the precedent and the common sense. So we ask you to uphold this search.
Counsel, I have one additional question. You know, we're talking about the legality of this and the language of the statute and the manual, but the context is somebody is being stopped because they put a part of a tire on the fog line. I mean, how I'm concerned about the broader implications of saying that now anybody can be stopped simply because they drifted a part of a tire onto a fog line. What do you make of the broader implications of this?
Sure, a couple of answers to that, Your Honor. First, if what we want so that officers use their discretion wisely is that bright line rules, which we talk about all the time figuratively and here literally, bright line rules are actually easier to apply. If you're watching, whether it's watching a video or listening to an officer's testimony, it's easier to say, did you touch or not, than have a line of whether you went over to the other side. Because frankly, once your tire's halfway over the stripe, whether you can even see whether you've crossed to the other side, it's easier to see touching or not. The other thing about that is, as the court below pointed out, that we, for simplicity, look at tires, but realistically, if you picture not just a stripe, but a plane in space, if there were a wall there, your bumpers and your side view mirrors are actually several inches over the line by the time you're touching. And sometimes, cars do scrape mirror against mirror. Happened to me once. That's unsafe. So touching the line actually means in space, your car is over the line. But the other thing ultimately where they suggest that officers might abuse this power by saying it happened when it didn't. No, I think first, not only do I have more trust in the honesty of our officers and our dash cams, but the fact that there's so many appellate court cases about just touching the lines says something about the honesty of all the officers across the state, that they admit openly, look, he just touched the line, he didn't go over. If you're going to say there was a touch when there wasn't, you might as well just say, well, he went all the way over, because after the fact, as between the officer's testimony and the person we now know was 2.5 times the legal drinking limit, let's be honest, this doesn't appreciably change how much discretion you have. You can pull someone over for being 1 mile over the speed limit. We don't often, but it's perfectly legal to do so. We don't get a free 5 miles that the court imposes into the law, even if in practice we don't give many tickets for driving 66 or 67. So there's no real expansion here. If anything, there's a clarification. Just like with any area of law, a bright line is easier to see and easier to apply than when you're sort of in the middle of the line or over the line. So this actually serves the purpose of clarity and doesn't eat away at it.
Thank you.
Thank you, counsel. Mr. Ferris?
Thank you, Your Honor. So there are several things I'd like to address. First of all, the idea of lane lines as buffers, frankly, is not found in the ORC, not found in the OMUTCD. It's an idea that the state makes up, for lack of a better word, to support their finding here. And there's a lot of examples that show just the opposite, including the language of the OMUTCD that was brought up earlier, which, in my opinion, makes clear that you're allowed to touch the line but not cross it. Second, if lane lines are buffers, then when we think about the fog line in particular, that would actually serve to push traffic back towards the middle, which frankly would be more dangerous. Lane lines are not required on one-lane roads, but one-lane roads do often have lane lines. And if they're not required on one lane roads, then they must not be required there as buffers. So if they're on the one lane roads, they must be there for some other reason, to provide notice, to provide warning for motorists. They're not being used as buffers there. The parked car and curb example provided by Mr. Horton, frankly, cars and curbs are not replacing the edge lines. There's reasons we can't touch cars and curbs. One, they're not part of the roadway, so they'd be excluded by the definition of 451101. Two, you can't just ram your vehicle into a curb or a car. And frankly, if lane lines were buffers, we would want lane lines in those situations to keep motorists away, under the state's reasoning, from parked vehicles or from pedestrians on the sidewalk. But since they're explicitly not used in those situations, it suggests again that the reason for lane lines is not as buffers, but as something else. And there's other examples in my brief from the OMU TCD showing that lane lines are not actually buffers. I'd like to address quickly.
Counsel, what about the point that Mr. Kearney makes that if you're driving on the lane line, okay, the fog line, your car's actually over the line because that's where your doors and the side of your car is, and how do you address that?
So that is not something that's ever been held to be prohibited by the revised code by any case or court that's ever looked at this, and that's going to create a whole host of problems. First of all, a lot of trucks
it's a problem to acknowledge that if the tire is riding along the white line, that the fact is part of the car is over the line.
So if we accept that, then we have to say that when trucks, especially big trucks and trailers, their tires wouldn't even be touching the line and their mirrors would be over the line and into the other lane. So those trucks, even without touching the line, would be committing a violation. And a lot of these vehicles wouldn't even be allowed on the road. They just would not fit. Plus, now we're creating a situation where police officers, and this is already a difficult situation for them potentially, but they have to imagine an invisible line down from somebody's mirror to the ground to decide if there's been a marked lane violation. That's just impractical. Frankly, it'd be unfair to drivers and unfair to law enforcement. And again, this would keep many legitimate motorists off the road. We would have to widen all of the roads if we were going to take that approach. I do have a few other points that I'd like to address. I see obviously that I'm over my time. If I'm allowed to answer them, I will. If not, I understand.
You've used your time. Thank you.
Thank you, Your Honor.
Thank you. We'll take the matter under advisement. You'll be notified of our decision. Our next case is 2019-1700, the State of Ohio versus Christian Carlisle. For the appellant, Mr. Mackin.
Morning, Chief Justice O'Connor, fellow justices, Deputy Solicitor General Bray, may it please the court. My name is Justin Mackin with the Lake County Public Defender's Office, and I would like to reserve 3 minutes for rebuttal. Separation of powers doctrine is born from our constitutional framework with a concern to ensure integrity and independence of each branch. In ORC 2909-15 D2B, which I will refer to here on out as the reduction provision, violates that constitutional framework. Now, broadly speaking, the statute requires the defendant convicted of an arson offense to register for a lifetime arson registry unless the prosecuting attorney and investigating agency allows the judge to consider the sentencing of a period not less than 10 years. That provision violates the separation of powers in 2 ways.
Counselor, what do you mean by the word allow?
Well, in our position, that the judge cannot consider anything other than a mandatory registration unless the investigating agency and the prosecutor says, we are allowing you, or we say we are okay with saying that you can consider this reduction.
It's a request, right, by the investigating, the arson investigator and the prosecutor.
Yes, but if at least how the this provision is written, if either the prosecuting attorney does not request it, or the investigating agency doesn't request it, then the judge does not have any kind of discretion. So,
but that's in the revised code. I mean, the General Assembly decided what what the registration requirements would be.
and that's why I would like to point to State v. Sterling, because the issue we have here is substantially similar to the one we had in that case, where a prosecuting attorney, before a request for by an inmate for DNA testing, could be reviewed for any decision by the judicial branch.
Was the prosecutor in this case opposed to a 10-year term?
In this case, no. But
so is this case even properly before us? I mean, was the problem here the judge said, I don't have any discretion to do this?
as I mentioned in my reply brief, there's two bases that I believe that we are properly here. The first being that the record doesn't have any kind of investigating agency. So as I mentioned before, we have to have both of these requests on the record.
But what about the judge? I mean, it doesn't seem here the problem was that the judge thought that he couldn't impose a 10-year term. The record seems pretty clear. He just didn't want to.
I disagree that the record is clear from that. There's several moments, both in the plea and the sentencing, where the judge says, I have to inform you that there is a mandatory registration without mentioning any kind of possibility of a reduction. And again, there is no mention of the requirements that the investigating agency would request that reduction. So not only...
Counsel, let me ask a question. If we agree with you and we sever out subsection B in its entirety, doesn't your client lose?
What I believe would happen under the Geiger test is that it needs to be remanded for resentencing. That the way that the unconstitutional
but if we eliminate the provision you're saying is unconstitutional, the only right the judge has is to make it forever for the life of the arsonist.
Well, so as I explained in my mayor brief, our position is that the portion, so we don't need to remove the entirety of D2B, but only a portion of it. Specifically, the conditional requirement that you can reduce it to a non-mandatory lifetime, not less than 10 years, if the prosecuting attorney investigating agency allows it. That
aren't we supposed to enforce the intent of the legislature? And they obviously felt that there could be a change, but only under certain conditions. So wouldn't we have to eliminate the entire provision?
I think there are two apparent intentions here. The first, which is mentioned in State v. Reed, that analyzed this registration, is that there's a need here to want to protect the public, but also, which is mentioned in State v. Dingus, that there's a apparent intention to have some kind of option that's not lifetime. And I think the best analogy to this is a decision this court made 4 years ago in State v. Nolan, where it was an issue about how the review was supposed to happen. So in that case, the specific statute was that an offender sentenced to death may appeal trial court's denial of application for post-conviction DNA testing by seeking leave of the Supreme Court. In that case, by taking out the leave of Supreme Court, the intention was still there. The overall scheme was still there, but the unconstitutional function was taken out. Our position is that the unconstitutional function to get to that exception is by giving the executive branch this unconstitutional power.
Counselor, if the prosecuting attorney and the investigator request that the registration period be for 10 years instead of lifetime, is it required, do you read the statute to require that the court make the registration 10 years?
Yeah, I believe that and actually that is how I would prefer the statute be severed, is that the judge just have that discretion.
Wait a minute. When you say, so they can make the request and the judge can deny the request and still impose the lifetime registration requirement, correct?
Correct.
then how is it that you're saying this executive branch allows or disallows or gets to control what the trial court sentencing or what the trial court decides with registration? The statute only allows the request. And I understand, I think the statute is problematic too, in that the request can only come from the prosecuting attorney and along with the investigative agency. That the way the statute is written, the defense counsel can't even make the request. But it is just a request. And although there might be some problems with the statute, how is it, if they cannot dictate what the trial court does, how is it a problem with separation of powers?
And to bring it back to Steve V. Sterling, so the way our position is that for Sterling, that I'm an inmate who wants to ask the court for a DNA test, but there's a stop in the middle, and the prosecutor either has to say, yes, you're allowed to move on, or they can stop it right there. Here, the request, it's completely at sentencing, that let's say the defendant wants to ask for some sort of reduction, but the judge can't consider that because there's a stop, just like there was in Sterling. If the investigating agency and the prosecutor doesn't also agree, the judge cannot consider it under how it's written currently.
Well,
so
counsel, it doesn't have to be even the defense attorney asking for it. If the judge, in their discretion, in sentencing, would like to impose 10 years, but their hands are tied and they have to do the lifetime appointment because the trigger to get to the 10-year, the lesser requirement, is the action by the prosecutor and the investigating agency in tandem. And I find that to be problematic because of the imposition it puts on the judge of not being able to use, there's a lesser registration requirement to be had, but the step to get there doesn't allow the judge to use discretion.
And I agree. And I think that's the overruling influence that was argued in Sterling. But I also want to move on to another point, that there's two ways that this doctrine is violated. One we haven't talked about is that this is a final decision. And again, it's kind of the same idea that I was talking about with this stop. This is a sentencing issue. So even in Sterling, where there was a relevant power of the executive branch to prove guilt or innocence, and DNA was related to that power, here is entirely sentencing. And by having this kind of stopgap from to the judge, they're making a decision that is appealable to no one. And just as it was found unconstitutional on that basis in Sterling, I agree that is an entirely separate reason that this portion of the statute is also unconstitutional. So there are two entirely different ways that we get to that point. So I do want to get back to the Geiger test, because I think that the issue here is going to be the way it reads. And I know we brought it up before. The first and third question is whether or not it needs any additional insertion of words or if it can stand by itself. If you take out every other word in this provision after if, then you have discretion. So the judge can decide a mandatory lifetime, not less than, or all the way up to not less than 10 years. That is a sentencing power that Mr. Carlisle is asking for. That's why he's asking that it be remanded so that his sentence is at least considered properly, that we're not sure if it was clear from the record that the judge believed she could. Even constitutionally, the plea would have been incorrect because there was no investigating agency on the record. And all of those issues are relevant here. But I think State v. Nolan, again, is the best example of where the ultimate framework of the statute was more important than the function that was not working. So just there where the way that the appeal was brought up.
Did the attorney at trial raise the argument that you're raising here?
the attorney at the police sentence made an objection. The majority below did believe that they didn't make a proper constitutional objection, but reviewed it on the standing issue that I also didn't mention before, but mentioned in my brief, that it is an issue of great constitutionality, that even if his mootness was destroyed, or his standing was destroyed on mootness, which I don't think it does, there's still a case law that supports that this case being reviewed. If there are no other questions, I'll conclude that this court should find that Ohio Revised Code 2909-15G2B is unconstitutional, to sever the language that affords the prosecuting attorney and investigating agency discretion to reverse the lower court's decision. Thank you.
Thank you. Counsel?
Good morning. Chief Justice, may it please the court. The arson registry statute does not invade the inherent power of the judiciary, and so is constitutional. It does not interfere with the court's determination of guilt. The determination of guilt is made by the conviction of arson itself, which subjects the person to the registry. So this is not the same as the Sterling case. And choosing the right sentence requires all three branches of government to be involved in some fashion. The legislature picks the range for the crime, sets the crime and sets the punishment. The prosecutor chooses what to prosecute, which itself may have effects on the sentence that's available and restrict some sentences from being available. And the judge imposes the sentence from among the options. This is how sentencing works. It is not an area where there is an inherent exclusive power of the judiciary.
Counsel, could the legislature write a law, let's just say a felony of the second degree, where a sentencing range would be 2 to 8 years in prison, and say the sentencing range is 2 to 8 years in prison. However, the judge cannot go below 5 unless the prosecutor gives their consent to this. Would that be constitutional?
I think it would, Your Honor, because the statute can set forth what the criminal penalties are, and the prosecutor has a role that's akin to the charging decision, the decision to plea bargain, the decision among which charges to pursue after an allied offense determination and merger is made. I don't think it departs from that. And in this case, certainly the finding of the arson conviction itself, that's the key fact that's determined, and that there's no question that the trial court made that finding here based on the defendant's no contest plea. And in terms of the sentencing process in the legislature, that has been a legislative area in terms of setting what the crime is, what the punishment is. That has been true for some time. And as this court has said, a sentence that is inconsistent with the sentencing statute is not even a sentence. And so
I know this question I'm about to ask you is not specifically before us, but how does this work? I mean, what factors are considered in a request to reduce the registration to 10 years? And does the trial court, excuse me, does the trial court get to inquire as to why there is that request, and do the requesters have to, set forth something articulable other than they like the defendant, or just some reason to request that the registration period be reduced?
Your Honor, the sentence doesn't specify factors. However, if the court were to look at the sentencing transcript in this case, which is the August 2018 transcript at pages 3 to 4, you can see how it plays out in this instance. The defense counsel asked for the reduced registration and represented to the court that the prosecutor did not, the prosecutor agreed with it. When the prosecutor stood up, he said, basically, yes, I do. I don't object to this based on his involvement in the case up to that point. To address a related point about the prosecutor and the investigating agency asking for this, certainly the prosecutor ordinarily works with the investigating agency and can be expected to speak really on behalf of both, since they're both representing the state. And there's no indication here that the investigating agency had any different view of this matter.
But so what the statute allows is the prosecuting attorney and the investigative, and what if the two of them disagree? If the two disagree, then the request isn't valid. I mean, if one of them agrees and the other does not, the court has no authority to reduce the registration period. Is that how you read the statute?
I think it can be read that way, although again, in this case, we certainly don't have any information.
I know what you're saying. I'm just talking about the logical inferences or what logically could happen here. Or if there was a particularly acrimonious relationship between defense counsel and the prosecuting attorney, the defense counsel might ask the prosecuting attorney for this reduction, and arbitrarily the prosecuting attorney could say no, even though the facts would warrant it.
Well, again, I think, Your Honor, we start from the point that the General Assembly has set out that this is a mandatory duty that flows from the arson conviction itself.
I agree. And again, I know we're looking at separation of powers here, but I guess it just seems strange that there would be the power from the perspective of the prosecuting attorney and the investigator to lower sanctions from a defendant when that's defense counsel's bailiwick, where you think they'd make the request, that they hold the power to initiate request and actually to initiate a lowering of the defendant's sanction when the defense counsel can't even do that. But as I said earlier, I whether it's a separation of powers issue is a different question.
To respond to Your Honor's question, a couple of things. In addition to the General Assembly's role, you have the role of the prosecutor in other instances to make the charging decision, when to plea bargain, when to send someone to a pretrial diversion program, and those are not thought to count as a separation of powers problem. To respond to that point, another analogy I'd offer for your consideration is under the state's previous indeterminate sentencing law, you had the adult parole authority essentially making determinations. You'd have an indeterminate sentence for a longer period of time, and the parole authority would decide really how long that person would serve in that prison term. And that, if you think about it, is not all that different from this situation where you have a prosecutor saying, well, I think this person might be a candidate for a lesser registration time. And again, bear in mind, the registry is not public. It is for access by the fire marshal and by certain fire personnel, presumably to assist in public safety and arson investigations, which can be somewhat involved. So this is a little bit different from some other things for that reason.
Counsel, you say the prosecutor has these post-conviction discretionary, well, not really. I mean, participation in a diversion program, which is the prosecutor's diversion program that, that's where it resides. So that's a little different. But here, where does law enforcement, the investigating agency, come in post conviction and kind of hold the strings on what the judge can do?
Well, as I said, there's separation of powers. Let me step back for a minute. Separation of powers is a matter of degree, as Your Honors know. It's not like each branch of government is put in a hermetically sealed box. And so you're going to have different interactions at different points in the system, and that's not a problem under separation of powers. And sentencing is a good example of that, because you've got the three branches with different roles that sometimes to a degree intersect, and that is allowable under separation of powers. I offered the analogy on the...
My question is, where does the investigating agency exercise that kind of authority? You have it with an elected prosecutor. You have it with other, executive branch, but I don't see it with the police.
All right, thank you. Thank you for clarifying. I misunderstood your question. I think that in most cases, probably 99% of cases, I can't imagine that you would have a discrepancy between the prosecutor and the law enforcement agency because they do work in tandem.
Why not just have one? Why not just have the prosecutor if they're aligned, but they don't? The statute says both. So explain that to me on how how this authority given to law enforcement can be exercised to thwart the discretion of a judge.
Your Honor, I would suggest that it's because it's unlikely to occur that this case doesn't present that, and I don't know that I would want to speculate too much on how that might operate in an unusual situation where there was a discrepancy in a recommendation, because it seems more like the way the statute is written. It's hard to say whether it's really an independent basis to block that, or it's more a recognition that the prosecutor and the law enforcement agency would be recommending together because the law enforcement folks would have had some interaction with the individual, as they did here. If you look at the defense counsel's comments, she said all the investigators had a positive opinion of her client.
As a follow-up to that question, couldn't the law enforcement agency just pocket veto it by not showing up, giving its opinion?
No, Your Honor, because I think, again, you would presume the prosecutor, who's the lawyer involved in the case, would be the one speaking to the court about the recommendation. And I don't think that would be unusual to think that that would be a recommendation from both, particularly if the law enforcement agency isn't coming in and contradicting it, as they certainly did not here.
But counsel, you would agree that the statute as written, even though you find it'd probably be unlikely, that as written, the investigative officer can, if you disagree with the prosecutor's recommendation to have it reduced as it was recommended in this particular case, he could say, no, I don't agree with that, and restrict the judge's discretion to act on that.
I think that would be an unusual case, and one to look at how this statute would operate at that time. But in any event, there have been other, since we're talking in either case about the executive branch, and they're both part of the executive branch, it's not unusual to have discretion in the executive branch at various levels, whether it's the parole authority, whether it's the governor and his pardon authority, or whether it's a prosecutor and the charge.
So the executive branch, obviously, you say, has many facets. And there's a big difference between a recommendation and the ability to thwart another branch of government from doing, exercising their authority. And here, it's not the recommendation that I'm concerned about, it's the ability to thwart. And that's, that rests with the police.
Well, I guess I would see it differently, Your Honor. I see it as almost like a separate charge. You can have, for example, you could imagine two charges, one with a mandatory lifetime registration and one with a registration that's subject to being lowered if the prosecutor or the prosecutor with the police recommended it. And we wouldn't think that having the two different charges with the two different results would be, as the results of an arson conviction, would be a problem under separation of powers. And I don't believe it is here either.
Just because a prosecutor recommends a sentence doesn't mean the court has to accept it. Correct?
In sentencing decision, that this is somewhat different from that, but I think you could have a statute where there could be a recommendation that was written in such a way that allowed the prosecutor to have a role in input in the sentence. I don't think that is off the table for separation of powers. purposes.
Is this a criminal sentence? I mean, is this a criminal punishment at all?
I think that's an issue, Your Honor, that you don't need to decide in this case, because either way, it doesn't affect the separation of powers analysis, whether it's punishment or not, although it certainly has some, it has characteristics of a civil remedial provision, which is what the courts of appeals have characterized it.
If it's not a punishment, isn't it a real easy question? I mean, the executive branch has all kinds of civil registration requirements. So if it's not a punishment, then it doesn't seem like any of these issues are implicated, would they be?
I would agree with Your Honor. I think that's a fair assessment if this is a civil remedial provision, and that is what the courts of appeals have characterized it as, and it certainly has those characteristics, although again, I don't know that you'd have to decide that here. If I may briefly respond on the severability point, as somebody noted, the Geiger test does talk about whether something can stand on its own. And here the language that the defendant would like for you to take out of the statute, if the judge receives a request from the prosecutor, et cetera, that can't stand on its own. So under the Geiger test, as it's been applied for the most part over the years, this would not be the proper way to sever it. And when I say sever, I mean hold unenforceable in this instance. The way to do that is, as we suggest in our brief, would be to take all of D2B out, which would then leave anyone with a lifetime registration. I see that my time has expired, and if there are no further questions, I thank the court, ask the court to either dismiss the case or affirm the judgment below.
Madigan.
Thank you. I'd like to address two specific points. The first being that the arguments made by the state have, in my opinion, a flawed basis of where the judicial branch and executive branch should end. I think one of the most egregious points was the answer to one of the justice questions, that if a range was from 2 to 8 years, but a prosecutor without an agreement could say, make it not less or more than 5, and that would be constitutional. In my opinion, that is implicitly and explicitly giving the executive branch.
Is there a criminal punishment in this case?
It is.
Why? It's purely a registration requirement. It's not. It's not available to the general public. It's a lot different than any. I think all the lower courts that have looked at the registry have said it's civil, not criminal.
So this is the second point I wanted to get to. So the first response I want to make is that State v. Williams made sex offender registration. They determined that was punitive.
But this is way different than that, right? I mean, it's.
I don't believe that there's any support for that. The language in State v. Williams is that notification and registration is punitive. There's no distinction that one is more or less punitive than the other. There's no case law that establishes that only notification but not registration is punitive.
Well, wait a second. State v. Williams, the court distinguished its prior case law, didn't overrule it, which said that notification requirements and registration in those circumstances were not punitive. And this seems a lot more like those than the scheme in Williams, doesn't it?
I disagree. I think that there's enough similarities in the registration, namely that it subjects you to a 10 years to a lifetime, where if you are on parole or PRC and you fail to register, then that's a violation. That in and of itself is a felony 5 if you fail to register. You have to register every year. In any violation of that subjects you to criminal punishment. I also want to go to a definition that was established in State v. Hand, where the court was looking at the difference between juvenile adjudication.
Before you do that, I mean, you would agree that if we conclude that it's civil, then there can't be a separation of power problems here, can there?
I still disagree, only because it would nullify the first argument I made, but I believe it's still a non-appealable issue. Even on a civil case, it would still be a non-appealable decision made by the executive branch.
Well, there's all kinds of non-appealable decisions executive branch agencies make.
At this point, the executive, so if I may continue.
Well,
the one thing I didn't get to go to a little bit in my rebuttal is the distinction of where the executive branch and the judicial branch are. We are past any kind of charging decisions. We are past the plea of guilty. All these decisions are being made at the sentencing level. And when the executive branch is able to start making decisions about how that sentencing is affected, even if it's this particular case where we're hypothetically calling it civil, I still think that's a non-appealable decision that still violates the separation of powers. If there's no further questions.
Thank you. Thank you. We'll take the matter under advisement and you'll be notified of our decision. Marshall, will you call a recess, please?
Court will now adjourn for a brief recess.
2019-1765 in the matter of the complaint of Suburban Natural Gas Company versus Columbia Gas of Ohio Incorporated. For the appellant, Ms. Boyko.
Thank you, Your Honor. Chief Justice O'Connor, honorable justices, may it please the court. My name is Kim Boyko, and I'm with Carpenter Lips and Leland. Today, I'm representing Suburban Natural Gas Company, the appellant in this case. I would like to reserve 5 minutes of my time for rebuttal. In the case below, the commission ignored Ohio law, the record below, the commission's own precedent, and this court's precedent in 3 respects. First, the commission failed to enforce a 1995 stipulation and releases and covenants not to sue that it approved. Second, the commission failed to find that Columbia implemented its builder incentive program in an unfair and anti-competitive manner to expand its service territory. Third, the commission failed to prohibit the unreasonable and unlawful duplication of utility facilities in contravention of the public interest. Ohio law is clear. A commission order must be reversed, modified, or vacated if this court finds it to be unlawful or unreasonable. The commission's orders in the case below are not only unreasonable and unlawful, but they depart from past precedent and are unsupported by the record. Therefore, appellant asks the court to reverse or modify. It's important to put this case into context. The dispute between these 2 parties began in 1986 when Suburban filed a complaint against Columbia, alleging that Columbia was violating Ohio law and its tariffs by providing various anti-competitive incentives to customers for the purpose of destroying competition, including free service lines and reduced rates. The commission agreed with Suburban and found that Columbia was unlawfully violating its tariffs. Then in 1987, Columbia attempted to revise its tariffs to authorize these anti-competitive practices. Suburban objected to Columbia implementing the same anti-competitive incentives that the commission had ruled were unlawful. The case resulted in Columbia implementing tariff restrictions, which explicitly prohibited Columbia from offering incentives to compete unless competitors also offered the same incentives. Over the years, issues continued to arise regarding Columbia's anti-competitive incentives and the duplication of facilities. So in 1995, the parties entered into an omnibus agreement by which the parties agreed to exchange certain customers and facilities to prevent duplication and to rationalize their systems, and to amend their respective tariffs to restrict builder incentives. In rendering its decisions in the case below, the commission overlooked this important history in the litigation that led up to the 1995 stipulation. The whole reason for the parties to enter into the settlement and the purpose of the settlement were completely ignored by the commission, as well as the explicit language of the stipulation. Appellee's interpretations basically render the 1995 stipulation meaningless. As this court is aware, contracts must be construed in their entirety and in a manner that does not leave any phrase meaningless. Additionally, when confronted with an issue of contract interpretation, this court has held that its role is to give effect to the intent of the parties, examine the contract as a whole, and presume the language of the contract reflects the intent of the parties.
Counsel, I'm looking at the language of the release, and it says, releasor, Columbia, further covenants and agrees that it will forever refrain from instituting, reinstating, or prosecuting any action or proceeding against Suburban. So how does that language support your arguments now?
Yes, Your Honor. If you continue on down page 2 of that stipulation, it says instituting or reinstating a program constituting, relating to, or based on the builder incentive programs, or any program substantially similar to such programs. The 1995 stipulation required both parties to list any incentive programs in the company's tariffs and restricted either company from paying incentives when competing with another company that does not also have those incentives. And consistent with 4905-30 and 32, the 1995 stipulation only authorizes incentives to the extent those incentives are actually approved by the commission and included in the company's tariffs. So what does the Columbia's tariff actually authorize? Well, if we look at the tariff authorizes a builder incentive program within Columbia's service territory and for energy efficiency purposes. The commission approved Columbia's application, specifically authorizing Columbia to pay incentives under the builder program only for homes located within Columbia's service territory and for customers served by Columbia. In violation of this energy efficiency program paid for by Columbia's customers, Columbia implemented the builder incentive program outside its service territory in competition with Suburban. Now, the Appellee has defined Columbia's service territory as the general geographic area where Columbia has facilities servicing or capable of servicing Ohio residents. Even using this expansive definition that may have absurd results, the Glen Crest development, the development at issue, fell outside Columbia's service territory at the time the incentives were offered by Columbia, and Columbia was not capable of serving that development. In order to serve the development, Columbia had to expand a mile worth of pipeline extension at no cost to the developer, and in doing so, the extension passed hundreds of homes already served by Suburban and duplicating Suburban's existing facilities. Record evidence also shows that Columbia's sales team used the builder incentive as a competitive response tool in order to expand its service territory. At the time Columbia offered the builder incentives to the developer, it did not have facilities serving or capable of serving Glen Ross residents. Therefore, the commission's conclusion that it is within Columbia's service territory when incentives were offered was unsupported by the record. And contrary to Appellee's claims, the commission has previously recognized established markets, and it has stated that incentives or special rates should not be used with the intent to raid the established markets of other gas utilities, as what was the case here. Additionally, if you look at Columbia's tariff, Columbia did not implement the builder incentive program for energy efficiency purposes as required. There's unrefuted record evidence that explained that the builder incentive programs did not encourage or incentivize more energy efficient homes, and the incentives were not strictly tied to energy efficiency initiatives. In fact, as mentioned before, Columbia's sales team admitted to using the incentives as a competitive response tool, not an authorized purpose. The commission has previously denied applications for energy efficiency programs where the program appeared to be a competitive response tool, competing for new load. Further, the commission has previously explained that it has never approved a rider with the intended purpose of a standalone program that was not directed to a utility's existing customers, but was then charged to those existing customers. The commission's conclusion that the energy efficiency program was used for its intended purpose to encourage energy efficiency programs within Columbia's service territory to benefit Columbia's customers who pay for those programs was unsupported by the record. The 1995 stipulation also specifically addressed the prohibition of duplication of facilities. Again, to settle the underlying issues in these cases as part of the 1995 stipulation, if you look at page 2, the parties agreed to transfer certain facilities and customers between the parties in order to rationalize each company's distribution system. And when the parties transferred customers to each other, they also transferred the right and obligation to serve those customers. The parties were separating their systems and transferring customers to prevent the duplication of system. Additionally, the 1995 stipulation contained a provision that only authorized duplication in certain circumstances. There was an exception. The exception allowed Columbia to construct high-pressure pipelines for purposes of transporting natural gas through Suburban service territory in order to serve other areas served by Columbia. If the 1995 stipulation did not prohibit duplication as a general matter, there would be no need to create this exception allowing duplication in certain circumstances. Instead, this entire provision would be redundant and unnecessary, which would contravene the requirement of the commission to give meaning to every provision in a contract. The stipulation also specifically stated that the commission retains continuing jurisdiction over this matter to supervise and assure the parties are in compliance with the 1995 stipulation. Again, if the stipulation had no application to prevent duplication of facilities in the future, this provision would be pointless. There would be no need for this provision. Allowing Columbia to needlessly duplicate suburban facilities is also not in the public interest, as customers have to pay for the duplication. Yes, the regulatory landscape in Ohio allows reasonable competition. The competition has to be reasonable among natural gas distribution companies. In Khalid, the commission recognized reasonable competition and that the absence of certified territories does not in and of itself defeat a cause of action against a competitor who duplicates facilities. Your Honors, Columbia violated the 1995 stipulation and exceeded the authority granted to it by the commission and its own tariff. It utilized the Builder Incentive Program as a competitive response tool to unreasonably compete with suburban and to unnecessarily duplicate facilities. The commission's orders were unjust, unreasonable, and not in the public interest, and they should be overturned or modified. Thank you.
Thank you. Mr. Lindgren.
Thank you. May it please the court. My name is Thomas Lindgren, and I represent the Public Utilities Commission of Ohio. I would like to reserve 5 minutes of my time for counsel for Columbia Gas. Your Honor, state law and policy permit and even encourage competition in the natural gas industry, as the Appellant's counsel acknowledged. Now, competition gives customers choices, but Suburban here is asking for a protection from competition, and that would have the effect of limiting customers' choices. Suburban seems to want to have an exclusive territory where they don't have to face competition. They want to be able to expand their service area while locking Columbia into the areas it already serves. I want to be clear about one thing. There are no exclusive territories for gas companies in the natural gas industry in the state of Ohio, as there are for electric companies. As the commission has stated, any certified gas company may serve customers anywhere in the state. Now, there's been talk about a service territory as the commission defined it. That's the general area where the company is serving or capable of serving customers. It's not exclusive and is subject to change. One company isn't locked into a particular area. It can expand that area, and that's what Columbia did here. It expanded its pipelines to serve a new residential development, as the home builder there chose Columbia. The commission reviewed the 1995 stipulation, which it had approved, and found that it did not bar Columbia from offering energy efficiency incentives or otherwise serving customers in southern Delaware County. The commission had approved this stipulation originally, and it's really in the best position to interpret that stipulation, and I would ask the court to give that interpretation deference. The stipulation resolved the dispute over particular customers, and it said nothing about energy efficiency programs or any geographic limitations on either company's ability to serve. There were some programs that were in effect then that were discontinued, but those are not comparable to the programs that we have now with Columbia, which are energy efficiency programs. They had no programs of that kind back in 1995. I would add that even if the stipulation could be read to limit competition or fix territories, that would violate state law and policy and would be unenforceable. I would offer the court an analogy. Say there were two law firms here in Columbus that had a dispute over who was entitled to the fee from a particular case. And they ended up resolving this case, not only over the fee, but saying, well, firm A will only take clients from north of Broad, and Firm B will only take clients from south of Broad Street. Well, I don't think this court would approve of such an agreement. In fact, I think it would violate the Code of Professional Conduct, and the court certainly would not enforce that. And that's basically what Suburban is asking you to do here, to enforce an agreement that in their mind limits customer choices. The commission also examined what Columbia was doing with its demand side management or DSM program. It looked at the order where it had approved these programs and found no violations. The commission further noted that an advantage shouldn't be taken away from Columbia just because the other competing company doesn't have a similar incentive. And I would like to make another point very clear. Suburban could have its own DSM program if it filed a proper application and obtained approval. Suburban had filed an application for such a program back in 2011, but the commission found it defective and sent it back. Well, for whatever reason, Suburban in the past 9 years has never even attempted to refile an application for a program that met the requirements. But customers shouldn't be penalized just because Suburban doesn't have this program, hasn't even applied for it. Customers should be able to take advantage of these programs when they're being offered.
Mr. Lindgren, what do you have to say about Ms. Boyko's comments regarding the energy efficiency standards that, as I understand, are saying that we're not really satisfied here?
Well, Your Honor, the commission so found that there were no violations of the energy efficiency standards. They found that that Columbia had complied with the commission rules and the commission order, and are those findings reviewable by us? Yes, but I would ask you to defer to the commission's factual findings in this area and defer to their expertise in this area. I would add that Columbia's DSM program is subject to an annual audit to make sure that all their money is being spent properly. And if the commission or staff finds any violations, that can be dealt with and money recouped for customers if it's been misused.
Thank you.
Your Honors, the customers in Delaware County shouldn't be denied access to the DSM program simply because Suburban is not able, really through their own choice of being able to offer the same program. Suburban had the burden of proof to show violations of the stipulation or any commission law or order. They haven't done so. They haven't met their burden of proof. This order is lawful and reasonable, and it should be affirmed. I yield the remainder of my time to counsel for Columbia Gas. Thank you.
Mr. Stem.
Thank you. Good morning. May it please the court. Mark Stem for Columbia Gas of Ohio. Columbia stands on its merit brief, but would like to offer 3 observations about Suburban's reply brief and the argument we've heard today. These will underscore why the 1995 stipulation is irrelevant and why Suburban's waiver and failures of proof below mean that this court need not reach Suburban's legal challenges of Columbia's DSM incentive program and alleged duplication of facilities. First, in a significant departure from its initial brief, Suburban at page 7 of its reply brief admits that Columbia's DSM energy efficiency incentive is authorized by tariff and not prohibited by the 95 stipulation when implemented for homes within Columbia's service territory. These admissions leave Suburban arguing, as it is today, that Columbia's use of the term service territory in its DSM application that was approved by the commission actually meant to exclude from the incentive program every home in the area that later became Glen Ross South in southern Delaware County. But that is precisely the definitional question the commission decided against Suburban, which Suburban chose not to raise for rehearing, thus depriving this court of jurisdiction to now consider it. We underscored this waiver at rehearing at pages 41 to 42 of our merit brief, and Suburban did not reply. My second observation concerns Suburban's argument that Columbia gained an unfair competitive advantage by simply publicizing the fact of its home builder program to Pulte Homes. That argument fails for many reasons, but certainly as a matter of evidence. The commission found that Suburban failed to prove that the program incentives even factored into Pulte's decision to select Columbia over Suburban. So the court need not reach the arguments that follow. Similarly, Suburban, as my third point, lacks the factual predicate for all of its legal theories for prohibiting duplication of facilities. Specifically, the commission did not find that duplication occurred as a result of Columbia's actions. Lacking these factual predicates for its arguments, Suburban is raising hypothetical legal questions and seeking advisory opinions. Now, turning to the issue of duplication of facilities in greater detail, the very label does not accurately characterize the work to bring natural gas to a never before served greenfield. Columbia's main constructed entrance.
Council, the pipeline that was put in that bypassed the suburban neighborhood and extended to this Glen Ross South, was that put in before the agreement was made with the builder?
Which agreement with the builder are you referring to, Your Honor?
The incentive program with the builder.
Okay, Your Honor, the incentive program that we're referring to was first approved in 2009 by the commission.
I understand that, but then it was offered to the developer, I guess, of this.
Yes.
Was the wrong term. The developer. Was the pipeline extended before that was solidified?
No, Your Honor. When the Columbia sales team was talking with the developer about all the reasons why Columbia could provide better service, the DSM incentive program was one attribute of what Columbia brings to the table, and that discussion predated the actual decision by the developer to choose Columbia. But there were so many reasons that Columbia gave that distinguished itself from Suburban. There's no evidence, as found by the commission, that the fact of the incentive program was actually the factor in the decision by the developer. And in fact, Your Honor, there's evidence in the record from Ms. Young, who talked to the developer directly about this. And the developer told her that the incentives were really a non-factor because they did not nearly cover the cost of meeting the energy efficiency standards in terms of the construction that would be required in addition to meet those standards. And when you think about the duplication issue, the main is just one small part of the facility's expansion to serve a new greenfield. There's also distribution submains for every subdivision street in this new 12-phase subdivision. And service lines have to be installed from the curb of every street to every of the 400 building lots, none of which duplicates anything Suburban has done. And Suburban was not displaced by Columbia's main. Suburban's main still brings natural gas to the 10 phases of residential development on the north side of Cheshire Road, among other parcels. And the Delaware County Deputy Engineer testified that it was commonplace in southern Delaware County for mains like this to run along each other or across each other, whether on one side of the street or on the same side of the street, in this case on the other side of the street. And the commission has long encouraged competition between natural gas utilities to provide the customer choice that Pulte Homes benefited from. And customer choice would be lost if the service provider was determined solely by which utility has the nearest pipeline. And we should note, Your Honors, that the Suburban's legal and policy objections to so-called duplication all evaporate whenever Suburban wins in competition for new large customers with Columbia. As we briefed at page 20, Suburban sees no issue at all when extending its main a mile away to reach and serve a new development where Columbia's main is already located. The disconnect here is that Suburban is seeking a double standard. Every argument Suburban makes in this case, and I should add, as noted at page 39 of our merit brief, every dubious perpetual service agreement Suburban has obtained outside of this case from owners of large undeveloped tracts, they are all aimed at extinguishing Columbia's right to compete in southern Delaware County, which Suburban seeks to protect as its exclusive service territory. I would like to address a couple of questions I heard while I was waiting. First of all, in terms of the releases on the stipulation, Nothing in the stipulation speaks to what's going to happen in the future. That was a very specific agreement that indicated it was resolving an existing dispute by exchanging facilities and customers. The releases to the stipulation did nothing but release Columbia's and Suburban's claims against each other relating to a series of listed builder programs, which were not commission-approved energy efficiency programs. They did not prohibit either company from engaging in any specific activities in the future. They simply preserved Suburban's right to file an action if Columbia engages in activities in the future in a specific area. They certainly contain no prohibition. And the contention today that we saw for the first time in the reply brief, that paragraph 10 of the stipulation, which concerns that high pressure pipeline mentioned. Note, Your Honors, Suburban did not raise at any time below or in its notice of appeal its argument that the 1995 stipulation contains one exception to the general ban it claims on duplication of facilities, and that the pipeline serving Glen Ross does not qualify for that exception. They cannot raise it for the first time in its reply brief before the Ohio Supreme Court. And I would note that the language of that paragraph does not support their interpretation in any event. With that, I would answer any further questions Your Honors have. If not, I would argue that the Commission's decision was clearly lawful and reasonable and should be affirmed. Thank you very much.
Thank you. Ms. Boyko, you've saved about 3 minutes and 50 seconds. You'll have to unmute your microphone.
Thank you, Your Honor. First, I'd like to correct a few misstatements. First of all, if you look at page 2 of the 1995 stipulation and then go to page 7, it actually does list the Mark of Efficiency program as an efficiency program that existed at the time, as well as 3 builder incentive programs. These programs are similarly situated and thus are prohibited by the 1995 stipulation. The 1995 stipulation and the interpretation of its very terms has always been at the heart of this case, and for counsel to suggest otherwise just does not make any sense. We have stated that the Commission failed to follow the 1995 stipulation specific language. On page 2 of the stipulation, it says that this case is a resolution of the parties' competitive dispute and rationalization of their distribution system. The duplication of the system has been at the heart of this issue from the very beginning. To be clear, Suburban is not challenging the energy efficiency program itself. It is challenging how Columbia is using the builder incentive program, a part of that program, as a competitive tool. Suburban did try to file its own builder incentive program as a competitive tool, and that case was rejected because the Commission said it never approved a rider with its intended purpose of a standalone program that was not directed to the utility's existing customers, but was charged to those customers. And to Mr. Lindgren's point, Suburban could not offer a DSM program to the extent of Columbia Gas. It has 17,000 customers, not 1 million customers. It couldn't spread the cost that could compete with Columbia. And that is the whole point. The energy efficiency program was just that. It was to incentivize energy efficient homes within Columbia's service territory. As Chief Justice recognized, Columbia went outside their territory, offered these incentives, and then had to construct a facility to be able to support and serve those customers. That is not prohibited, or that is not allowed by both the 1995 stipulation as well as the energy efficiency program itself that was approved by the Commission and put in its tariffs. Columbia can expand its territory. No one is arguing that it can't, but it has to do it in an anti-competitive manner. And it also has to do it with reasonable competition. It can't use builder incentives in an improper way. 490533B prohibits using free service or incentives to destroy competition. And 490535A prohibits causing undue or unreasonable prejudice or disadvantage to a company. that is exactly what Columbia is doing under the guise of an energy efficiency program. The Commission has historically exercised its authority to prevent duplication of facilities for public utility service. It's in the public interest. Customers end up paying for the duplication of facilities. The Commission has the authority. It's used it in the past. Appellees have not demonstrated why natural gas utilities should be treated differently than any of the other utilities that don't have certified territories. The Commission should prevent duplication of natural gas facilities. The public interest actually mandates that it do so. Columbia violated the 1995 stipulation. It's using its energy efficiency program in an improper manner that exceeds the authority granted to it, and it should be reversed. Thank you.
Thank you. We'll take the matter under advisement and you'll be notified of our decision. Our last case today is 2019-1769, the State of Ohio versus Roger Simpson. For the appellant, Ms. Troutman.
Chief Justice and Justices of the Court, may it please the Court, my name is Rachel Troutman, and I represent the amicus curiae on behalf of Roger Simpson. I'd like to reserve 3 minutes for rebuttal, please. So the Ohio Public Defender, as amicus curiae, urges this court to reverse the lower court's decision and to hold that at that initial application stage of a 26B, an applicant should not be required to demonstrate that he conclusively demonstrate prejudice. A genuine issue of a colorable claim should be something less. That should be reserved for the second stage of the application process, 26B. So requiring an applicant to establish prejudice for appellate ineffectiveness in that application stage, it does not fit with the purpose behind 26B. Essentially, the courts are deciding the underlying issue before they're ever hearing the case on the merits. So the purpose of 26B is to give defendants that opportunity that they missed. And it started with State versus Moynihan in this court. It's a means for enforcing that right to the effective assistance of appellate counsel. As this court recognized,
how do we determine effectiveness versus ineffectiveness if prejudice isn't part of the equation?
Well, Your Honor, it is not that prejudice would not be a part of the equation. It's simply that the standard should be lower. At that application stage, most of the applicants are pro se.
Before you go on, lower than what specifically?
We have provided some language in our brief that is potential standards that this court could use. For example, in the Certificate of Appealability in federal court, the standard is a kind of a probable cause standard. And essentially, the jurists of reason simply have to be able to conclude that the issues presented are adequate to deserve encouragement to proceed further. That is more of a standard. That is more of a workable standard for an applicant who is not represented by counsel, who doesn't have access to the full record. In fact, the rule itself contemplates that the applicant may not have the record available to them at the time they're filing their application.
But then what then prevents an applicant, let's say a pro se applicant, from then raising every possible thing or matter that appellate counsel did not do, some instance of which might have been strategic or had no chance of prevailing? How do we discern between those colorable, I guess, deficiencies by counsel versus those that are not?
Well, Your Honor, those should be ferreted out, but that should not occur necessarily at the application stage. If an issue deserves encouragement to proceed further, then in that full briefing, if there's strategy issues at play, all of that could come out in the briefing. And at that point, the court does not have to grant a new trial or sentencing phase. Because the win here, a win for a 26B application, is simply the ability to file a brief.
Is that issue even in front of us?
Your Honor, the issue...
Are you kind of asking us just to write a kind of advisory opinion? Isn't that...
No, Your Honor. The issue before this court with regard to State versus Rogers Simpson is the proper test for appellate effectiveness. Mr. Simpson's counsel has proposed...
We accepted a specific proposition of law that deals with applying the MAPES factors. And it seems like the party that advocated that proposition of law isn't even arguing, and you're arguing for something that might be useful, but it's certainly not the issue in the case, is it?
Well, actually, Your Honor, the appellant did, in fact, present in his brief that although he used the MAPES factors as his guide, that the first stage should apply the MAPES factors in a lower burden. And then during the second stage, the MAPES factors would be used as a whole. So even if we presume that the MAPES test is the proper test for this court to adopt, it is a useful tool. It could be a useful tool for this court. But the reason we feel that the MAPES test is not the appropriate test for this court is because when you look to how MAPES came about, the Sixth Circuit created MAPES by reviewing its own history as to what it found compelling in an ineffective assistance of counsel claim. And so they essentially listed out all these different holdings in which they found that to be a compelling reason to reverse the case. But this court has its own precedent. This court has its own reasons that it could list out for reasons for determining appellate counsel is effective or not effective. But regardless of whatever standard that is ultimately applied to determine the issue of appellate effectiveness, there has to be some sort of clarification at the very least for the underlying courts, because like the 12th District did here, the courts of appeals are not, they're combining the two steps into that first application inquiry. We see this in the lower court opinion here, and we see it across the districts in Ohio. There's cases such as State versus Snyder and State versus Fain, in which the dissenting judges in both of those cases pointed out that we have an issue of, in these cases, the majority's analysis is denying the appellant the ability to develop and expand his legal argument in that brief below. All of the issues are being decided in the application. Again, most of these applications are pro se. So we're expecting pro se inmates who aren't even advised of their right to appellate effectiveness as counsel to then present their own arguments that appellate counsel missed, to do it within 90 days of the filing of the opinion, to attach affidavits, and do this all without access to the record. As a practice, when we take these cases, when we find these cases, for the most part, or sometimes the record's not even complete. So we have to spend the time getting the transcript. We've had attorneys pay out of their own pocket to have the transcript, to have it transcribed in order for the applicant to then be represented on appeal. So what we get then is meritorious claims are being missed. And one example of that is when you look at this court's language in State versus Roberts, and then you compare it to the language in State versus Goff. So in State versus Roberts, this court discussed, you highlighted the importance of the right of allocution in capital cases. And citing State versus Green, 2000 case, State versus Campbell, a 2000 case. State versus Goff, the same issue, the right of allocution, was raised, but in a Murnahan, in a 26B. And no genuine issue was found by the court. So the application was rejected. After the Sixth Circuit, after full briefing, and the Sixth Circuit had the benefit of full briefing, they reversed the issue and remanded it back down because there was a genuine issue. The right to allocution does matter. So you'll also see in our brief when we cited State versus Schleiger, another case in which the federal court had to fix what the 12th District didn't do, because the 12th District was applying the standard before ever having the briefing in front of it. So one of the proposed standards that we put in our brief is simply the definition of colorable claim. And you get that from Black's Law Dictionary. And that is, a colorable claim is one that is legitimate and may reasonably be asserted given the facts presented and the current law, or a reasonable and logical extension or modification of the current law. The further extension of that is that it could be a fair probability or likelihood, but not a certitude of success on the merits. Courts of appeal are requiring applicants to demonstrate success on the merits. And again, without access to the record, without access to counsel, which doesn't come until that second phase, they are unable to meet that burden. At this point, Your Honors, I would like to reserve the remainder of my time for rebuttal unless you all have any questions.
Thank you.
Thank you.
Madam Chief Justice, and may it please the court, Shamsirji for the Attorney General and in support of the state. This case presents the court with a dilemma. Simpson asked this court to take this case so it could consider adopting an 11-factor checklist for measuring counsel's performance in the context of claims based on ineffective assistance of appellate counsel. Simpson claimed that the Sixth Circuit, which first articulated these factors in Mapes versus Coyle, had adopted these factors for itself, and that were this court to follow the Sixth Circuit's lead, it would harmonize Ohio and federal law and lead to more predictable and stable outcomes. But it turns out that the Sixth Circuit does not, in fact, rely on the Mapes factors, at least not with any consistency, and it almost never relies on all of them at one time.
But does that prevent us from adopting them in whole or in part, or using them as guidance?
Your Honor, so I think this is a point of agreement actually between the public defender and our position, and that is that we don't think that Ohio courts should shun their eyes from the Mapes factors. We think that they certainly can look to them to the extent that they think they are relevant. But we don't think that this court should require appellate courts to apply every single one of these factors or any particular number of these factors every single time that an appellate court is confronted with an ineffective assistance of appellate counsel claim.
Then what is it that you think that a court of appeals should do? Because the assistant public defender stated that court of appeals are looking generally to see if there is an indication of success or merit success just from the applications in and of themselves on the first submission, and uniformly denying those before you can even get to the substance. Isn't that missing out on the colorable claim? In this case, I take, for example, the facts in this case, in the underlying case, even the issue of consecutive sentences here. If my understanding of the facts is we had a trial court judge who imposed sentences on 3 co-defendants, 1 5 years, 1 8 years, and 1 51 years. Now, I understand, of course, the difference between plea bargains and the benefits of that and getting some counts nollied or deleted. But when you come to consecutive sentences, the trial court looks at the conduct, not the counts. So you have a trial court judge deciding that the conduct of 1 of 3 defendants who are individually and responsible for their individual conduct and each other's conduct, that consecutive sentences totaling 51 years was warranted based on the conduct of 1, but that only 5 and 8 years is warranted for the conduct of the other. So that there, to me, raises a colorable claim that the sentence should have been challenged by appellate counsel in this case.
I appreciate the question, Your Honor. So I want to sort of take that in 3 parts. First, I don't think that this is the case for this court to announce any new standards on this issue. And that is first and foremost because that's not what this court accepted an appeal on. So it just has not been adequately briefed by the state, by Simpson himself, and even the public defender, which has briefed this issue more than any of the other litigants in this case, did not, I don't think in either of the public defender's briefs, actually apply their standard to this case. So Justice Stewart, everything you said may be true, but unfortunately we don't have the benefit of briefing, even from the public defender who is making this argument in applying the standard that they prefer to the facts of this case. Second, I should just note, we don't quarrel too much with the public defender on their particular formulation of this standard. I think they call it a reasonable likelihood of success. I don't understand that to be saying anything much different than what this court has said in its precedents when it has said that it looks for a colorable claim, or the language in the rule itself, which includes the term, I think, genuine issue. All of those, I think, basically say the same thing. But I think more important, and this gets to point 3, than the particular formulation that this court settles upon, is recognizing that all of these standards, even at the application stage, are ultimately applying the underlying Strickland standard. Therefore, properly applied, even at the application stage, they are according, and they should accord, a great deal of deference to trial counsel's performance. There should be a strong presumption, in the words of Strickland, that counsel performed reasonably and that the proceedings were. It's a tall burden for an applicant to show that they have made a genuine showing or a reasonable likelihood that they were denied effective appellate counsel. Are there mistakes made in particular cases? Sure, and we don't deny that.
But as counsel said, shouldn't we get to the part 2 of the 26 of the April 26 motion that oftentimes we don't even get to that evaluation because there isn't clear proof in the initial application that appellate counsel was ineffective or that the applicant would have prevailed on appeal?
Well, Your Honor, I certainly don't think that we should get to it in this case. And the public defender, again, didn't brief that issue. So I think the most prudent course, honestly, is because Simpson himself isn't here to press his argument about the MAPES factors, and because the public defender hasn't briefed how the standard that they're pressing would apply in this case, it is for this, I think the most prudent court is for this court to just dismiss this case as improvidently accepted. But I don't think that proceeding to the second stage was warranted in this case. Nobody has really developed an argument other than Simpson for that. And Simpson relied on this argument based on MAPES, which, it turns out based on even a cursory amount of research, isn't borne out in the case law. The Sixth Circuit doesn't apply those factors, and he isn't here to clarify his argument or to explain why this court should adopt those factors, notwithstanding that.
Thank you.
Sure. So I would just reiterate that we think that the proper course for this court to take is to dismiss this case as improvidently accepted, or in the alternative, to affirm the judgment of the 12th District. If there are no further questions for me, Your Honor, then that is our respectful submission to you today. I thank you for allowing me to present the Attorney General's case.
Thank you. Counsel?
Thank you. The Ohio Public Defender does not represent Mr. Simpson. So no, we did not apply our standard to his claims, but that in no way should render Mr. Simpson's case as improvidently accepted. To dispute what the Attorney General said, if you review Simpson's brief, he most certainly did apply his the MAPES factors to his claims. So that point is simply because amicus counsel has decided that these issues also affect us. They affect a lot of our clients, and we felt that this court might like to look at it a little differently. But the issue is the same, that whether we're at the application stage applying the MAPES factors, or if we're simply applying Strickland versus Washington, which is what this court has determined is the test, and what the U.S. Supreme Court has determined is the test, the applicant himself should not be required to demonstrate prejudice. If you look at the language that courts are using to determine whether there is a colorable claim, a genuine issue of a colorable claim, it is the exact same language that is used once an application is actually granted and the cases are reopened. It's the same prejudice inquiry. An applicant who is pro se, again, who does not have access to his own record and certainly doesn't have the legal expertise to present his own claims, certainly isn't going to be able to make that showing. So this court needs to clarify for the lower courts what that standard actually is. And if they need to use the MAPE factors in determining how to get to that lower standard, then that would suffice as well. But this court needs to make sure that the lower courts are not holding these pro se applicants in 10 pages within 90 days to the same standard that they are held if they actually get their applications accepted. If this court has no further questions, I would just rest my case.
All right, thank you. Thank you.
Thank
we'll
you, Your Honor.
take the matter under advisement and you'll be notified of our decision. Marshall, will you adjourn court, please?
Hear ye, hear ye, hear ye. This open session of the Honorable Supreme Court of Ohio now stands adjourned.